Dear colleagues, we continue our working day, and the topic of current press briefing is as follows: judicial power, urgent problems. We have Vladislav Rudenko, judge of Starobeshevskiy district court in the Donetsk region, Andrey Ivanov, judge of Perevalsk district court of Lugansk region, and Bondarenko, judge of the Commercial Court in Kiev. Good afternoon, dear colleagues. The topic of our briefing is devoted to possible options how to resolve issues in the judicial issues in judicial power. In particular, on January 1st, we had the statutory meeting of the Association of the Judges of Ukraine. We decided to register our organization. We will raise the qualification of judges and assist in solution of the professional issues, also control the compliance with the judges' rights. At the same time, we understand that the judiciary branch should be changed, and it requires new level of transparency and new information policy based on the ideas of the rule of law. I would like to explain in simpler language. Quite often we hear about judicial reform. There is a broadly discussed statement that the judges have to change themselves. So our initiative group had united on the basis of the on the framework of Bar Association of Ukraine, and we organized the section. We have the section of judges, and we decided to carry out some initiatives. Thus, we offered several initiatives to the Council of Judges. We tried to assist them. We also appealed to the Verkhovna Rada, pointing out to the violations of the rights of judges, the procedure as to the judges. Our colleagues worked in the temporary commission on the judicial reform. We made several attempts to cooperate with MPs and to offer some initiatives aimed at improvement of the judiciary power, specifically aimed at the independence of judges. During this year of our work, we several times felt that we should establish our association of judges in order to promote self-governance of judges. We united with the purpose to unite just ordinary judges, and we intentionally had written down in our statute that chief judges, leading judges of the Supreme Court cannot occupy any positions in our association. In Ukraine, we have three self-governance bodies of judges: the Council of Judges, the Council of Judges of Ukraine, which are elected by the Congress of Judges. But unfortunately, the Council of Judges cannot, this Council of Judges, which comprises 33 members, it cannot carry out its functions, all its functions efficiently. That's why the aim of our association is to cooperate with the Council of Judges. We believe that later we will sign up a memorandum on cooperation with the Council of Judges, and thus we will represent judges from the regions, from cities and towns. For example, it is planned that very soon there will be sessions of the qualification commission, qualification assessment of judges, and our intention is to provide information and raise awareness among ordinary judges about this new procedure. That is what we wished to inform you about. And also I would like to explain that we are not alone. We are not only one NGO which unites judges. We have several associations of judges, and we expect to cooperate with them fruitfully. We have Ukrainian Association of Judges. Recently, they held several roundtables on changes to the procedural legislation. We have Association of the Commercial Court Judges, and we also plan to cooperate with them. The second topic of our briefing, which united us. This is a non-election of judges for lifelong period. Currently, we have the procedure for appointing judges into the position of a judge. First appointment is scheduled for the period of 5 years, and after this initial period, it is appointed for the lifelong period. 6 months prior to the expiration of the primary period, the application should be submitted to the Council of Judges. Then the Council of Judges has to make its decision, send its recommendation to the Parliament of Ukraine. Then the Parliament of Ukraine has to issue resolution about lifelong appointment of a judge. And after this procedure, a judge could be appointed for the lifelong period. Unfortunately, Verkhovna Rada does not have any strict procedure for appointing of judges. The last such sitting of Verkhovna Rada was in May 2015, and currently there are more than 600 judges who have to be appointed into lifelong term. This should be done by Verkhovna Rada, but they cannot do their cannot carry out their professional duties. That is, they receive their salaries, but they cannot work as judges. Actually, in some courts, there are no more any judges who have this right, who are officially appointed by Verkhovna Rada to carry out this judiciary function. We appealed to many instances to the President of Ukraine, to Verkhovna Rada of Ukraine, to the Council of Judges of Ukraine. Unfortunately, this issue about the proper procedure and nobody wishes to take responsibility and vote for the appointment of judges in the midst of the judiciary reform. But now we are in a situation when we expect that new legislative provisions are expected to start to come to force next summer, and by the next summer, or even by the end of this year, 2016, several hundred of judges will be deprived from their professional duties, actually. There is another problem. Those judges who are not appointed to the lifelong position, they cannot be reappointed to another courts, and those judges who were reappointed from the occupied areas from in the east, they cannot be reappointed to another courts. And now my colleague will present situation with those judges who came from that area. Those judges who disagreed with the occupational regimes, they became IDPs and relocated to the mainland Ukraine, and immediately they faced a lot of difficulties. There is obvious violation of their labor rights. The majority of those judges who relocated to mainland Ukraine from occupied areas, actually, they stopped receiving their fees, and all the state guarantees to them in line with the labor code, they all are violated, and the situation persists till now. We have several dozens of judges who were not officially relocated from occupied areas to new positions in mainland Ukraine, and actually they remain in very difficult situation. 77 judges had not get new positions in non-occupied territories, and the payment of salaries to them had been stopped. We also plan to devote much attention to this issue. High Qualification Commission of the Judges of Ukraine is open to the dialogue in this area, and they lacked actually proper communication between this commission and those whose rights were violated. We believe that our association will become a good bridge which fill this gap. Also, the draft law offered to the parliament for passage during the last session unfortunately did not get sufficient support from MPs, and unfortunately the situation remains in actual collapse, and judges cannot survive. So we have resolved the issue of those judges who remain in this hand position, and we expect that we will be able to promote passage of the draft law. I also would like to add about major activities of our association. We would like to pay more attention at the lack of voice in the court. When mass media covers some events which happen in the court, and they are quite tough often to distort the situation, and ordinary people can perceive wrongly the situation in the court. That's why we decided to strengthen communication with civil society, raise standards of judiciary in the society, and to raise public awareness among ordinary population. Thus, we plan to explain to people some broadly used terms like detention, pledge, collateral, violation of the rights, the search, court decision, and verdict and court judgment, etc. And the difference between all those things. It is important to inform public at large about the most basics of the court activity. That's why we invite mass media to cooperation, and we have one more aspect which we would like to cover. I would like to add association of the judiciary self-governance association in Ukraine plans to establish the court journalism department in the Lviv Catholic University. We plan to teach journalists how to cover properly and correctly those events which happen in courts, and how to explain to people what's going. And the fourth topic of our briefing, there is constitutional reform and opinion of the Constitutional Court of Ukraine. There is decentralization reform and reform of the constitution in the aspect of judiciary branch. We all agree that changes are necessary. The constitutional process on this in this aspect continues. There is a draft law on the changes to the constitution. This draft law gained positive opinion of the Venice Commission. A week ago, the Constitutional Court of Ukraine produced its opinion on this issue. The Constitutional Court reviewed the draft law against compliance of two articles number 101 and 128. That is, it checked whether the draft law cuts down the rights and freedoms of Ukrainian citizens. It studied whether there is a martial law in Ukraine, whether changes to the constitution could be done, whether changes to the constitution won't violate territorial integrity, whether projected changes won't violate the rights and freedoms of citizens, whether the draft law was passed with the compliance of the procedure. Taking all this into account, the Constitutional Court came to positive opinion that the draft law could be passed by the parliament from constitutional point of view. We believe that this draft law will be amended during passage in the parliament, and there are a lot of suggestions as to amendments and changes to the law presented both by broad public, by professional community, and by MPs. And thus we are optimists and believe that the draft law and changes to the constitution will be optimally positive. We hope that there won't be any political pressure upon judges in result of those changes in constitution. There are some risks inherited in the final provisions and transitory provisions. For example, about appointment of judges, the future of those judges who are appointed for the primary 5-year period. We would like to make a remark for all Ukrainian citizens and to send a message that the opinion of the Constitutional Court is part of the part of the procedure on making amendments to the Constitution. First, Verkhovna Rada had to say its word. And the Constitutional Court has made its formal opinion about, based on Article 157, about possible violation of the rights and freedoms of citizens. The Constitutional Court made no conclusion and made no opinion about the plot of changes in the judiciary. So what we wish to put an end to this period of changes, and we are dreaming about quick passage of this reform. But actually, transitory provisions of the draft law on amendments to the Constitution in judiciary are reflected in 313 56th item that those changes does not limit rights and freedoms of Ukrainian people, but in transitory provisions of the draft law, they bear some risks and they contain some reservations as to the constitutional reform. There is a set of risks which we discussed during roundtables, and we presented those risks to MPs. Thus, this is about those judges who are primarily appointed for 5 years. Those judges remain dependent on their status. It is suggested to terminate the first term and reappointed to the position of judges. Now the question is whether those judges whose term in the office expires in 2018, whether they could feel themselves secure. At the same time, everybody is equal against the legislation, and while different procedures for appointment of judges are suggested by the draft law. Those judges who are appointed for lifelong period, they will be subject to qualification assessment, and there is very detailed procedure for qualification assessment, which is prescribed by a special piece of legislation. Those judges who are appointed for 5-year period, they could be divided into 2 categories. One category are those 600 whose period in the office already expired. They should be appointed by the Council of Judges. Those judges whose period in office will finish after passage of the draft law and becoming in the law will be defined by the further law, which will be passed at some moment in the future. This split into 2 categories, depending on the moment of appointment to the position, considerably decreases positive effect of making the judiciary independent. We wish to explain to society that these are citizens who are interested to have independent judges. So these were the risks. Judiciary reform should be based on the predictable and transparent procedure for judges' appointment in the future. Thank you, dear colleagues. Maybe journalists have any questions. Since there are no further questions, thank you for coming, and see you next time. Dear colleagues, our next and the last briefing for today